We all know that mediation has gained significant momentum in resolution of disputes, both in India as well as across the world. In countries like USA, 90% cases are settled before they go to trial. This is particularly so in disputes relating to commercial issues. The people who have been mediator in cases would know that there are miracles happening when disputes get resolved. Disputes which have been pending for 2 decades, 3 decades, are resolved over 4-5 sittings in mediation sessions. Disputes get resolved by merely giving an apology, saying sorry. So where does this magic come from? The number of commercial cases are increasing. They are getting complex by the day. We have the Singapore Convention on International Mediated Settlements in commercial contracts. We have recently had the Mediation Act in India, just 2 months back. So what is this magic? Where does this come from? That complex cases, long pending cases, are getting resolved in several sittings, which in a court proceeding or even in arbitration is not possible. So technically our session is over. We are running against time. So I will start with the questions straight away. And my first question goes to Veena Ralli. She has a distinction of having done more than 1,000 mediations. One of the most successful mediators of our country. Veena, we would like to know from you, what is the cause of this magic when people come to mediation?
Neelam, mediation is magical. When we started mediation, we started because of overloaded dockets. And there was a situation where it was realized that maybe we have to go for alternatives to the adjudicatory process. So people were trained, mediation started. I'm one of them who started at the initial stage itself. But over a period of time, we realized the benefits attached to the mediation are magical, and this process does not only look at the outcome, it looks even at the relationship. Be it personal, be it matrimonial, be it commercial, be it organizational. In nowhere in adjudicatory process the relationship is given any value. Rather, the damage is so much that it's further cemented by one judgment in favor of one, and again it is taken into appeal. And parties look at each other as enemies. But when you come to the magical room of mediation, the techniques the mediator is supposed to use, I'm very carefully using the word supposed to use, they bring the magic in the beginning itself. And a mediator navigating the parties through the length and width of the techniques which are required to be used for the purposes of mediation brings them to a level where they start collaborating for resolution of their disputes. They are the decision makers themselves. In the adjudicatory process, somebody else decides for them. And nobody wants my problem to be decided by someone else, but we have no other option. But there their role changes. So that is the magical wand in the hands of the mediator. And for this I will emphasize one thing, that mere 40 hours training is not enough. You need to understand the nuances of techniques, not only of the communication but negotiation as well. The lawyer may say, so far what has happened? Lawyers have been trained for mediation. So we see it from the perspective of lawyers only. But I feel that even if under the Commercial Court Act, it has been made mandatory, the voluntariness attached to the mediation has not been taken away. a question might be bothering on the people sitting on this side with me and to you also. Once it is mandatory, so where does the word comes for voluntariness? Voluntariness is attached to the process. And if a trained, well-equipped, well-talented mediator is there, he can navigate the parties through the whole difficult, challenging situations while using his techniques, making it throughout voluntary, but still driving them towards resolution. That's challenging, of course. But by experience, we have learned, and I'm sure anybody can do it. So even if it is mandatory, voluntariness has not been taken away. There can be something called, once it is not mandatory, so why people should go? There, our system is such, we are avoiders. We want to avoid outcome at the earlier stage. देखेंगे अभी थोड़ी देर देख लेते हैं क्या होता है. And there, under the Commercial Court Act, if we see the litigation cost being evaluated at the time of computing the cost, this aspect can also be kept in mind because the authority under the Commercial Court Act is Delhi State Legal Services Authority so far as Delhi is concerned. And there is a fee given for that. So that will be computed. And then a question further will be there where there was a reasonable offer coming from one side, but unreasonably refused by the other side. So those aspects are still there. So as a mediator, while discussing the initial benefits of mediation, we must bring this aspect also to the knowledge of the participants, so that they know that there is a benefit if I agree today. It is an executable award, and definitely the parties are going to be benefited for all times to come. And the most important thing, relationship is not damaged at all. Or even if not repaired, at least further damage is taken care of. I think
Thank you, Veena. So it is the mediator's magic which transforms and empowers the parties to be able to collaborate. And this is from a stage where most of the time the parties, the relationship, there is a complete breakdown, there's no communication. So it is the magic wand of the mediator, how with his skill and techniques, how he does that. Moving forward, commercial contracts. In commercial contracts also, relationship is equally important. My next question is to you, Abhay, since you are at the helm of commercial cases. Given the increase in complex commercial disputes and your vast experience in the field, do you think mediation offers a viable option for a speedier and less expensive resolution of disputes?
Thank you for the question, and thank you all of you for being here. I think there's a very interesting trend that's taking place with mediation today, which is that because of Section 12A and the requirement for us to actually have clients engage in it, we're seeing in positive results. We're seeing disputes which appear to be complex because of the nature of the transaction, but come down at times just to money. So I think, considering that things are getting better with the Commercial Courts Act, litigations are being shortened, but not to the extent where large institutions are comfortable constantly being in court. And mediation does allow you to circumvent that entire process by engaging with a very competent and talented mediators at the Delhi, especially in Delhi, who are able to, at least in commercial transactions, because there's no, unlike let's say a family dispute, there's no ego involved. It usually just involves, rupee paisa ana. And once you are able to structure payment plans, once you're able to structure terms, you find that that GCs, companies in general, clients that we have, are more amenable to using the mediation route because overall it's more cost effective for them. I can give a simple example of how mediation, even when it's not under the auspices of the act, we have an arbitration. It's highly contentious, and when the arbitration proceedings started, got a call from the other side saying, would your clients be interested in having a conversation? And until this point in time, we hadn't had one. And so because of now the experience that we're getting with mediation proceedings, I advise my clients to do it. And I believe we're at the cusp of settling a matter which would have otherwise taken up a year and a half, 2 years, would have taken up significant resources on both sides. And with no guarantee of either side being successful, because it was one of those cases where it depended completely on an interpretation of a particular clause. So overall, I now advise clients to at least explore the possibility of engaging in mediation, because I feel that even as a lawyer, if you're dealing with clients who are you work with closely and for long periods of time, the trust then is there that when I say, let's go to court, that they understand that there is no real other possibility, and that lawyers are not in it just to be in court for the sake of being in court, and that they have the client's best interests, both financial as well as reputationally, at heart.
Heartening to know that more and more mediation is being used to resolve commercial disputes. Getting to the underlying interest is important. And in commercial disputes, it's mostly money. Yeah. Moving on, my next question is to Sarika. I'm given to understand that mediation was not made mandatory under the Mediation Act due to a lack of availability of qualified mediators. Though in the bill, it was made compulsory. As Secretary General of Maadhyam, International Council for Conflict Resolution, could you tell us what role can private service providers like Maadhyam play to build capacity and bridge this gap?
Thank you, Neelam, for your question. Maadhyam has been pioneer in the mediation movement in India. It is engaged in capacity building and propagating mediation at all levels. You know, Maadhyam has been training individuals from last many years. In the last 1 year, we would have had, I think, more than 3-4 training sessions, and most of our members are trained by international organizations like Strauss Institute for Dispute Resolution and also SIMI. So we have internally built the capacity already. With the new act coming in force and with the mediation institutions getting now the mediation cases, and it will develop further in the due course, Maadhyam is already ready to provide services to the public, which is the need of the hour. Section 12A, as we already discussed, is already, there is a mandate of mediation there. And Maadhyam has, domain knowledge and expertise also, because we have a lot of senior lawyers as members of Maadhyam. So domain knowledge today, like Section 12A mandate, is very important for mediation. Maadhyam provides or is ready to give these kind of special services in the field of mediation.
Thank you. That's good work being done by Maadhyam. Coming to you, Saurajay, you are a practicing lawyer at the Supreme Court of India. Given your background as a litigating lawyer, are there any other ways to introduce a requirement for mandatory pre-litigation mediation other than under 12A? And how to ensure that it is taken seriously by the parties?
Thank you, ma'am, for having me. So, just briefly to start off, 12A, while a party has to, while initiating any proceeding, they do need to explore the option. Of course, they can avoid that if they have an urgent interim application on board. But once, let's assume they don't for a moment, even though generally always such an application does follow. Even if they don't, when the matter reaches the mediation cell, what next happens is an offer, or rather a notice is issued to the other side. Now, the other side can very well say no. If they say no, the matter ends there. It goes forward. So what I've been noticing as well, and especially in my experience, it's been happening more in international commercial arbitration agreements, where there are, of course, foreign parties involved. what's happening is that they have a mandatory mediation conciliation exercise that needs to be carried out before you can actually invoke arbitration. So your arbitration clause is dependent on first having explored that option. So once a party, when we are entering into contracts, the parties are not perhaps at loggerheads at that point in time. So they would be more amenable and open to having such a clause because, of course, as everyone said, it may be a more economically viable and better solution, rather than having a situation where disputes have arisen, and as it was rightly said, it mostly is money terms, but sometimes also in these situations, I've seen ego coming in the way, quite often as well. So if you have a clause such as that right at the start, subsequent to that, if disputes do arise, that's the first way of ensuring that actually the exercise is carried out. So essentially there are two hurdles, primary ones in my view. One is to getting them together. Second is, of course, how do we ensure that it's taken seriously? So the first could be sorted out by such a clause being there in an arbitration agreement as well, which says before arbitration invocation, you have to actually explore settlement, you have to explore mediation and conciliation. The second is how do we take it seriously, which briefly ma'am had touched upon on the cost aspect of it. There's a principle which has evolved and it's been enforced for quite some time in the common law countries. It's called the Calderbank letters. So essentially it gained prominence through this 1975 judgment, even though it was in a divorce matter. The issue that happened, it arose there is, even though the husband did receive about £10,000 as a divorce settlement, on the issue of costs, the wife said that I had made an offer for about 12,000 before, which had been refused by the husband. So the court, while determining the costs payable, and especially in foreign jurisdiction, the costs are quite high. So for the costs payable, the court held that no, the husband has to bear the costs. Because what had happened is that a reasonable offer was made. And what finally, you did refuse that offer, and you went ahead with litigation. You were not able to gain an amount which is higher than that particular offer, and in fact, the offer made was higher. So you'll have to bear the costs. Now that is the second way. And in fact, in India, especially in international commercial arbitrations, more that I'm seeing, is a situation where actual, more or less, realistic costs are being awarded. Of course, there is a reasonability line to it as well, because one may not have 4 firms involved or 3 firms involved and 4 senior advocates involved, so they're not going to pay you for that much. But depending upon the matter and depending upon the complexity of the matter, somewhat reasonable costs are being awarded, and which is to an extent realistic. So in that situation, and if it does, so let's say for example, a claimant, a plaintiff in this situation, a claimant, let's say, before going in, we had a discussion. I made an offer, being the respondent. The claimant refused. Going forward, the matter went into arbitration, and what the claimant did end up getting is around or less than the offer that I had made, even though the claimant had in fact won the matter. The tribunal might, while deciding costs, make costs in my favor in that situation as well. So that is an interesting line, and in fact, in some situations that does happen, but it's mostly in an international commercial arbitration aspect. And also the other thing is very important over here is that even in domestic arbitrations, if the tribunals start, and it started as well, but there's a long way to go on that front, if they start actually giving real or close to real costs, then that is always an aspect which will play in the back of the mind. So broadly speaking, those are the 2 hurdles, and one way is costs. Costs is a way of actually sorting that out.
Thank you. Our mediation law, does not provide for any consequences of a party refusing to participate in mediation. So I think some kind of sanction cost should be there, like some jurisdiction. UK has it. They impose sanctions if the party is not coming forward to at least try, give it a shot at mediation. Veena, I want you to come in here. Since you are at the helm of affairs at the Delhi High Court Mediation and Conciliation Center, Samadhan, many a times we see when the court send the parties to mediation, they come and say, we did not want to do it. So how do you handle those kind of situations?
See, first of all, even in legal profession, we have not taken mediation seriously unless we really experience it. So the parties who are not aware about the mediation process, they feel this is another courtroom for them. Maybe a judge is sitting who will force them to decide or take this option or take that option. So that is why the credibility of the process depends upon the person who is holding the process in his or her hands. There is a specific process attached to the mediation as well. Generally people feel mediation क्या है? एक को कमरे में बुलाओ, दूसरे को कमरे में बुलाओ, दोनों जहाँ agree कर जाए वो mediation है. My answer to that is it's not mediation. Mediation has a skill. There are techniques to bring the parties to create options and then select the option. So when the parties come with such a mindset in the mediation room, the mediator has to meet them, greet them and treat them in such a way that they feel that this is a place where they can look at their interest, not by digging into their positions, which they generally do in court. And one important aspect which is very, very relevant for all of us to know is that in courts we have a dispute which is surfaced, which everybody knows, but nobody knows the conflict between the parties, why this dispute has arisen. So once you disclose them the process and encourage them to participate, even if in the beginning they say no, because the judge told us we have come, but you can transform the parties and bring them to a level, at least they are ready to talk to you as well as to the opposite side. So it all depends upon the person who is holding the process in his hand. And I think magic can be done at this stage itself.
Thank you. So this is where the skill and the training aspect becomes important. My next question is to Preet. Singapore and Hong Kong have created mediation ecosystems, settling and deciding multi-billion international commercial disputes. India is looking at being the hub of ADR in both arbitration and mediation here. Under Section 12A of the Commercial Courts Act, pre-litigation is mandatory. Does Section 12A help in popularizing and maximizing the resolution of commercial disputes through mediation?
Yeah, so, I mean, your question has two legs to it. I would try to answer the first one first, which is how other countries like Singapore and Hong Kong and some other jurisdictions also, they have become hubs of ADR. It all started primarily with arbitration and then mediation has picked up. India lags behind on many counts. One of those, of course, we have tried to address when we have tried to have now time-bound ADR processes so that it is a faster process. But to really popularize our country as a venue, what has to be done, and the answer lies in your question when you spoke of ecosystem. We need to have a robust ecosystem of institutes who would administer a mediation or an arbitration. You need to have physical infrastructure. Like in Singapore, they have Maxwell chambers where all of that is, most of the arbitrations can take place. I think in India, we still lack that sort of an physical infrastructure. Of course, offline mode is, I think, a better mode when we talk of things like mediation, like other than an online mode. Because when you meet a person face to face, you are able to connect with them and understand their views better. I mean, we see that every day, even in our meetings, you know, the online mode cannot always take over the meeting, the people. And, you know, often when you talk of commercial disputes, these are between people who were working together up till a point of time, and they were like colleagues. You know, we often see, okay, two companies, impersonal people and fighting with each other. It's not like that. You have been dealing with your consultants since ages, and then there is a dispute, or some service provider, you were sitting with them working on a project, and then there is a dispute. So it is important you have that physical infrastructure where parties can meet and settle disputes, and not to mention the entire ecosystem of mediators and lawyers who are also trained, you know, in-house lawyers who are trained to educate people on what is this about. Incidentally, what I feel can be a big drawback to this entire process is the overall resistance to initiate any new proceeding in between. Because most of the time what actually happens is you presuppose people haven't really discussed their disputes before initiating arbitration, whereas that happens. Often, 6 months, 1 year has already elapsed before a dispute proceeding starts. So then somebody will question that what benefit would a mediator bring to the table, or would these proceedings bring to the table, because we have already tried discussing. So then again, as and when parties see the benefit of this entire system, that is going to be a stepping stone or a starting point where this process becomes more acceptable. And as and when, something becomes popular, the ecosystem develops, and then, you can think of becoming a global hub. And that's how, maybe Section 12A, which mandates this proceeding as a mandatory step, because voluntarily nobody would have gone for it. They would have said, we have already tried talking. But if it is a mandatory process and then they say, yes, this gives us some value, we are able to settle the dispute, save on cost and time, and that is where actually you will see a change coming. But a lot depends on how we develop the overall ecosystem and the infrastructure around this.
Since time is a constraint, I'll come back to you on the connected question. This Mediation Act aims to institutionalize mediation. Aims to institutionalize mediation. What, according to you, because you mentioned the need for a proper ecosystem to meet the increasing demand for mediation, what, according to you, are the steps required to achieve this objective of the Act?
So when you say steps required, one step has already been taken. They have said that the Mediation Council of India would be set up to, impanel or monitor the agencies who would be mediators. Second step, of course, is, like I said, developing the entire ecosystem of mediators who are lawyers, not necessarily people coming out of the court system as retired judges, but because they are in that adjudication mode, but maybe people who are from the industry themselves, who know how to tackle disputes in a non-confrontational way, having institutions to train the mediators, and generally to have awareness sessions around this new law, because something which is very new, people don't understand, and then there is resistance. And I think the biggest challenge right now would be to educate people that this is something which has happened, and this is how it can work in your favor. And then, have contracts which have unambiguous clauses. Because I can see a lot of litigation happening around it that we never had a mediation clause to start with, so why am I required to do this?
We have the arbitration clause. How many disputes
revolve around that? Yes. So even with the mediation clause, how to draft it? How will it work? So, I see there is so much which has to be done just to make this a seamless process, and not again another step where, parties are litigating and arguing about. So I think awareness sessions are the first thing which has to be done.
Thank you. I come back to you, Abhay. Considering your field of work and given the mandate under Section 12A, would your firm recommend mediation to all your clients in commercial matters? If yes, why? You did say that you are telling your clients to go for mediation, but why do you think that is a preferred option?
I think to come back to what I was saying earlier, I think it comes down to cost effectiveness of mediation, and the fact that when you're dealing with corporate and commercial disputes, you're looking at either compliance with terms, or you're looking at services being rendered, products being provided, or payment being made. A lot of the times when both parties understand that, because, as everyone here is aware, mediation also allows you an opportunity to suss out the other side's arguments. Because in order to justify your demands in mediation, you do put across your points. Now, what we're finding is that lawyers are getting better and better at having very different personas when they're mediating for their clients as compared to when they're in court.
They have to wear a different hat.
You have to wear a different hat, because otherwise you're doing injustice to your client, because you're not able to maybe take them to a point where a settlement is possible. But yes, as I'm finding, as the mediation sector matures under the Commercial Courts Act, we're coming to a position where law firms and advocates across the board are more find it more conducive to at least attempt mediation and to see where it heads. And I feel that it'll just go from strength to strength.
Great. Thank you. Saurajay, the Mediation Act makes the mediated settlement agreements enforceable as a decree. Do you think this is going to help increase the magic of mediation?
Yeah, so coming back to the Commercial Courts Act as well, even 12A, it's supposed to be drawn up as an award under Section 30 of the Arbitration Act. Now, one has to also look at 96 of the CPC, because then it's a consent decree, effectively. So, if you're looking at it from that perspective, just because the Mediation Act says it's going to be drawn up as a decree, and your Commercial Courts Act quite clearly says that it's going to be treated as an award, from what has happened on the enforcement front under the Arbitration Act, is that if it's something, and of course, you've got grounds of fraud only to challenge under 96, a consent decree. So what effectively will happen is that an arbitral award will effectively be treated as a decree of the court as well, without you having a right to challenge under 34 until you say there is fraud. So in both situations, yes, the terminology used is a little different, but even in 12A, by virtue of being referred to as an award, it still has the same force as a decree because it's a consent one. And just to wrap up the previous point we were talking about on the reasonability bit, if one has a look at our cost regime in 31A, 3D, it also says one of the factors the tribunal is supposed to look into is whether a reasonable offer was made or not. So that's the other bit. Yeah, thank you.
Thank you. Sarika, being responsible for resolving a large number of disputes for any organization is a stressful occupation. Actually, Preet can also pitch in here. Should all internal counsels be trained in mediation, skills and techniques to bring the other party to the negotiating table?
That's a very relevant question you have put, Neelam. See, in the previous session, we heard all the general counsels say that today GCs are involved in everything, every aspect of the business. Therefore, I mean, maybe I'm biased. I'm a trained mediator from last 15 years. So I always propagate mediation. And I have seen it helps in the, organizations as well. So, but a lot of sensitization is required. You know, as we evolved, and Veena has told us, mediation is relationship building. Relationship building is important even in the big companies. You know, at certain points, I see there is a dispute with one of the business partners, but one of the business unit within the group would say, sorry, we cannot break the relationship. The other one is wanting to go legal and, snap the ties at any cost. But the other person is standing in front of me and saying, sorry, the business won't be able to run. And that's the point when I have to convince them to try mediation before taking any other action. So I feel a lot of sensitization within the companies is required. Sorry.
Yeah.
Yes. So just to add on to maybe what was said earlier, see, a lot of awareness is required, and also in-house counsels would have a great role to play in this new form of process also, because obviously when you are talking of drafting of your your offers for settlement and what correspondence has to go, it is mostly, at least in larger conglomerates, the in-house team which does that correspondence. The initial dispute correspondence and the notice is done in-house. And when we are looking at, mediation and what is it that is required, I think that is one aspect in which in-house counsels would need training, because most of them wouldn't have drafted, this sort of an offer for settlement and ancillary proceedings. And generally, To act as a mediator, I'm not sure because there would be a conflict of interest, but definitely that is something which I think in-house counsels, being close to the business and often, negotiating a lot of deals for the business, are more, or are actually in a better position to develop a sort of an offer. Because especially if somebody has seen the genesis of the contract and the dispute and can see it more objectively than people on the ground who have suffered, or they feel they have suffered at the hands of the other party, they are better equipped to come up with solutions. So yes, I think in-house counsels, it's not an option. They have to be trained in this system now.
Thank you, Preet. Now we've already run out of time. Let me have your quick comments on the topic of the day. Veena, let me have your comments first.
I started with magic. I'll just say one thing, that court annexed mediation started in 2006. Today's Delhi's success rate at the district court level is very high. At Delhi High Court, it is about 50 to 55%. Court annexed mediation centers are generally approachable and approached by lawyers. So lawyers need to be aware about this part, that they can take their clients to this site and get them what they want. I will call it a mediation advocacy for specifically required for mediation purposes. Commercial Courts Act was introduced in 2015. Rules under this act were introduced in 2018. Immediately thereafter, because rules were framed in July, COVID came. And after that, at the initial stage, there was no infrastructure even. And in the absence of infrastructure, it was difficult to implement the provisions of the Act. It took time to establish a system by which now court annexed mediation centers are doing mediations under the Commercial Court Act. And today's success rate at our center, that is Samadhan, is about 30 to 33%. So what I say, that our journey of 3 years has got us 1/3. I think we can approach further and we can reach up to 50% very soon, once we have mediation advocacy very much available to us.
So I think mediation and conciliation is an extremely important tool which has to be used properly, and I think Abhay rightly touched upon it as well, is that the lawyers have to actually practice it in such a manner where they try to close matters out. So personally, I try to get as many matters settled as one can, and of course the settlement can happen at different stages of the proceedings. So one has to be, as a lawyer, as your client's representative, you have to look out for your clients, and you have to ensure that you actually try, in whichever manner possible, to close the matter out through settlement. Whatever stage it may be. It may not be in the initial stage at all. It could happen at a subsequent stage as well, because that's the definite art of getting a matter settled, because then that determines your strategy towards it. So yeah, that's very important.
They say mediation never fails. Even if the parties go back in the first round, there are chances of them coming back because they have been transformed to some extent. Yes, Sarika?
Yes, I'm for the title of the topic for the day today, that mediation is a magic wand, and the more, there is a mandate of mediation. I told everybody that Maadhyam is ready. We have the capacity to provide services of mediation, and even as an in-house counsel, I would say it will be easier for the in-house counsel if there is a mandate of mediations. We will have more sessions of sensitizing our colleagues within the organization, and they will also be ready to adopt this method.
Yeah, so yes, it has the potential to be a magic bullet, but I think it will have to stand the test of time, that how well is it adapted and what roles the legal community can play, because it does require a bit of rewiring of the lawyer's mind, not to extend the dispute and maybe let it end. Maybe somewhere everybody needs to do a bit of introspection and provide incentives for ending the dispute to the lawyers, because it should, in 6 months, obviously they cannot bill that many billable hours. So maybe higher rates for settlement or something like that. So, but yes, I think it's a good step and it can help in really reducing the disputes.
Abhay will have the last word.
No, I think there's very little to add to what's already been said, but I think you're looking at, as India, since 91, as was said in the previous panel, India as a economic market and ergo a legal market is definitely maturing. And I feel that as you have alternate dispute resolution processes abroad, we're moving towards that. And I think both the entire ecosystem, being the stakeholders, being your clients and advocates themselves, are understanding the benefit of it. And I do believe that apart from cost, I think trust is always the most important thing a lawyer has. And if your client trusts that you're able to offer them cost-effective solutions which protect their interests, they are in the long run going to trust you. And that would just, you'd build on that, on those relationships, and it'll just be mutually beneficial to everybody involved.
This trust of lawyers has come a long way. Let me just share a fact which you may not be aware. When in 2005, the first mediation center was set up in Tees Hazari. Veena will have more details of that. It was vandalized by the lawyers. They pulled it down. And it was then sitting, then president of the Delhi High Court Bar Association was summoned by the Chief Justice. And he said that we will have this center, we will have it at High Court. And subject to one condition, it will be run by the lawyers. So this was the first step towards gaining the trust of lawyers in mediation. They thought we will be this thing rendered jobless if the mediation picks up. So anyways, now we all concur and hope that this magic bullet is off to a flying start. Thank you, panelists, for your time and expertise and giving us such wide, diverse perspectives. And thank you, everyone, for your patience